Hello, my name is Brant Hunt. Today is the 31st day of December 2022 as I continue to share with you the Redemption Manual 4.5. I am actually live here. I'm doing a portion of this book, and my channel is Discerning What is True on YouTube. So we're going to continue to read this particular book because it's just filled with massive information that is actually true. A lot of the information is coming from Eustace Mullins' works, what we call The Secrets of the Federal Reserve. So we're going to continue on here. So thank you for being here and enjoy. So we're going to start out with the House Joint Resolution, explaining what the bankers didn't want or don't want you to know about the realities of modern day finance. They shatter most of the public religiously held assumptions about money and banking. What the general public thinks it knows about money and banking is largely based upon a collection of canards gleaned from a TV or a quote unquote radio or newspaper and their own personal experiences with money and banking. In the following pages, you're going to find out where a high bank official admitted that bankers do create checkbook deposit credits to the credit of their clients' checking accounts as their loans and investment payment funds. You will also learn how an attorney has successfully avoided a bank foreclosure because the banker admitted to creating the checkbook credits as the funds it loaned to its client. In the landmark case that no one probably has ever heard of, my words here, this very few people know anything about this. And it's critical for you to hear this because it needs to be echoed throughout people who are seriously trying to find the truth. So in a landmark case that is court decision, which was follows, a Minnesota trial court held the Federal Reserve Act to be unconstitutional and void. The National Banking Act to be unconstitutional and void, and declared a mortgage acquired by the First National Bank of Montgomery, Minnesota in the regular course of its business, along with the foreclosure and the sheriff's sale to be void. This decision, which is legally sound, has the effect of declaring all private mortgages on real and personal property and all U.S. and state bonds held by the Federal Reserve, national and state banks to be null and void. This amounts to an emancipation of the so-called nation from personal, national, and state debt purportedly owed to this banking system. Every so-called American owes it to themselves, his so-called country, and to the people of the world for that matter, to study this decision very carefully and to understand it. Upon it hangs the question of freedom or slavery. On May 8, 1964, Mr. Jerome Daly, D-A-L-Y, executed a note and mortgage to the First National Bank of Montgomery, Minnesota, which is a member of the Federal Reserve Bank of Minneapolis. Both banks are privately owned and are part of the Federal Reserve banking systems. You hear what he's saying is a privately owned bank. Okay. In the spring of 1967, Mr. Jerome Daly was in arrears of $476 in the payments of this note and mortgage. The note was secured by a mortgage on real property in Spring Lake Township in Scott County, Minnesota. The banker foreclosed by advertising and bought the property at a sheriff's sale held on June 26, 1967. Mr. Jerome Daly made no further payments after June 26, 1967, and did not redeem within the 12-month periods of time allotted by law after the sheriff's sale. Excuse me. The bank bought an action to recover the possession of the property to the Justice of the Peace Court at Savage, Minnesota. The first two justices were disqualified by affidavits of prejudice, the first by Mr. Daly, the second by the bank. And the third judge refused to handle the case. He was then sent pursuant it to law to Martin V. Mahoney, Justice of the Peace of Credit River Township, Scott County, Minnesota, who presided as a jury trial on December 7, 1968. The jury found the note and mortgage to be void for failure of a lawful consideration and refused to give any validity to the share sale. Verdict was for Mr. Daly with costs an amount of $75, that is. The acting president of the bank, Mr. Lawrence V. Morgan, admitted that the banker created the money and credit upon its books. I'll read that again, folks, because you need to hear it. The acting president of the bank, Mr. Lawrence V. Victor Morgan, admitted that the banker created the money and credit upon its books by which it acquired or gave as consideration for the note. That this was standard banking practices, that the credit first came in existence when they created it, that he knew of no United States statutes which gave them the right to do this. This is the universal practice of these banks. Mr. Lawrence V. Morgan appeared at the trial on December 7, 1968, and was perceived to be candid, open, direct, experienced, and truthful. He testified to 20 years of experience with the Bank of America in Los Angeles, the Marquette National Bank in Minneapolis, and the plaintiff in this case. He seemed to be familiar with the operations of the Federal Reserve System. He freely admitted that the bank created all of the money or credit upon its books with which it acquired a note and mortgage of May 8, 1964. The credit first came in existence when the bank created it upon its books by ledger entry. Further, he freely admitted that no United States law gave the bank the authority to do this. There was obviously no lawful consideration for the note. The bank parted with absolutely nothing except a little ink. Note, it has never been doubted that a note given in a consideration which is prohibited by law is voided. It had been determined, independent of acts of Congress, that selling under the license of an enemy is illegal. The emission of bills of credit upon the books of these private corporations for the purposes of private gain is not warranted by the Constitution of the United States and is unlawful. No complaint was made by the banker that the bank did not receive a fair trial. The admission is made by Mr. Lawrence V. Morgan. The path of duty was clearly made and very direct and clear for the jury. Their verdict could not reasonably have been otherwise. Justice was rendered completely and without denial, promptly and without delay, freely and without purchase, conformable to the laws and the courts of December 7, 1968. Following pages presents the ruling for the original pleading, the appeal, and the testimony given at Mr. Jerome Daly disbarment proceedings brought by the Minnesota State Board of Law, Justice Martin B. Mahoney. You heard the case, handed down the two opinions attached and included herein. The appeal's determination are by far the most stunning. Its reasoning is sound. It will withstand the test of time. This is the first time the question has been passed upon in the United States. I predict that this decision will go into history books as one of the great documents of the so-called American history. It is a huge cornerstone wretched from the temple of imperialism, money kings, and planted as one of the solid foundation stones of liberty. So this is forwarded by Associate Judge Bill Drexler. The Credit River decision, handed down by a jury of 12 on a cold day in December in the Credit River Township Hall, was an experience that I've never experienced. Was an experience that I never forget. I'm sorry. The Chief Justice of the Minnesota Supreme Court had phoned me a week before the trial and asked me if I would be Associate Justice in assisting Martin B. Mahoney, since he had never handled a jury trial before. I accepted, and took me 2 hours to get my car running in the 22 below zero weather. I got to the courtroom about 30 minutes before trial and helped get the wood stove going, since the trial was being held in an unheated storeroom at a general store. This was the first time I met Justice Martin B. Mahoney, and I was impressed with his no-nonsense manner of handling matters before him. My job was to help pick a jury and to keep Mr. Jerome Daly and the attorney representing the Bank of Montgomery from engaging in a fistfight. The courtroom was highly charged, and the jury was all business. The banker testified about the mortgage loan given to Mr. Jerome Daly, but then Mr. Jerome Daly cross-examined the banker about the creation of money out of thin air. Mr. Jerome Daly asked the bank president, if you were just opening up your bank and no one had yet made a deposit, hear me now. This is vitally important, folks. And I came into your bank and wanted to take out a loan of $18,000. Could you loan me that money? When the bank president said yes, I thought the jury would faint. See, they've been lying to us for over 100 years, folks. They've been lying to you. And one person actually told the truth. Mr. Jerome Daley then asked, does this mean that you can create money out of thin air? And the banker president said, yes, we can create money out of thin air. Justice Martin B. Mahoney then said, it sounds like fraud to me. And everybody in the courtroom nodded their heads, indicating that they agreed with Justice Martin B. Mahoney. I must admit that up until that point, I really didn't believe Mr. Jerome Daley's theory and thought he was making this up. After I heard the testimony of the banker, my mouth had dropped open in shock, and I was in complete disbelief. There was no doubt in my mind that the jury would find for Mr. Jerome Daley. Mr. Jerome Daley had taken on the bankers, the Federal Reserve banking system, and the Money Kings lenders and won. It is now 28 years since this landmark decision, and Justice Martin Mahoney is quoted more often than any Supreme Court justice ever was. The Money King boys that run the private Federal Reserve Bank soon got back at Justice Martin B. Mahoney by poisoning him in what appeared to have been a fishing boat accident, but with his body pumped full of poisons in June of 1969, less than 6 months later. A great price for justice, folks. Both Mr. Jerome Daley and Justice Martin B. Mahoney are truly the greatest men that I have ever had the pleasure to meet. The Credit River decision, as it is known, was and still is the most important legal decision ever decided by a jury. Bill Drexler. Note, Bill Drexler was subsequently disbarred for his role in the Credit River credit case. Now here's the District Court, State of Minnesota, County of Scott, First Judicial District, First National Bank of Montgomery, Minnesota, plaintiff versus Jerome Daley, defendant. The above entitled action came on before the court and a jury of 12 on December 7, 1968. At 10 a.m., plaintiff appeared by his president, Lawrence B. Morgan, and was represented by his counsel, Thomas Theodore R. Melby, M-E-L-L-B-Y. The defendant appeared on his own behalf. A jury of talesmen were called, and panel, and sworn to try the issue in this case. Lawrence B. Morgan was the only witness called for by plaintiff, and defendant testified as the only witness in his own behalf. Plaintiff brought this as a common law action for the recovery of the possession of Lot 19 at Fairview Beach, Scott County, Minnesota. Plaintiff claimed title to the real property in question by foreclosure of a note and mortgage deed dated May 8, 1964, which plaintiff claimed was in default at the time foreclosure proceedings were started. Defendant appeared and answered that the plaintiff created the money and credit upon his own books by bookkeeping entry as the consideration of the note and mortgage of May 8, 1964, and alleged failure of consideration for the mortgage deed, and alleged that the sheriff's sale passed no title to plaintiff. The issue tried to the jury were whether there was a lawful consideration and whether defendant had waived his right to complain about the consideration having paid on the note for almost 3 years. Mr. Morgan admitted that all the money or credit which was used as a consideration were created upon their books, that this was standard banking procedure or practice exercised by their bank in combination with Federal Reserve Bank of Minneapolis, another private bank. Further, that he knew of no United States statute or law that gave the plaintiff the authority to do this. Plaintiff further claimed that the defendant, by using the ledger book, created credit by paying on the note and mortgage, waived any right to complain about the consideration, and defendant was estoppel from doing so. At 12:15 on December 7, 1968, the jury returned a unanimous verdict for the defendant. Now, therefore, by virtue of the authority vested in me pursuant to the Declaration of Independence, the Northwestern Ordinance of, it should be 19, that can't be 1978, it should be 1878. The Constitution of the United States and the Constitution and the laws of the state of Minnesota not inconsistent therewith. It is hereby ordered adjured, and decreed that plaintiff is not entitled to recover the possession of Mile 19, Fairview Beach, Scott County, according to the plat, therefore on file in the Register of Deeds office. That because of failure of a lawful consideration, the note and mortgage dated May 8, 1964 are null and void. That the sheriff's sale of the above described premises held on June 26, 1967 is null and void of no effect. That the plaintiff has no right, title, or interest in such premises or lien thereon is above described. That any provision in the Minnesota Constitution and any Minnesota statute limiting the jurisdiction of this court is repugnant to the Constitution of the United States and to the Bill of Rights of the Minnesota Constitution, and is null and void, and that this court has jurisdiction to render complete justice in this cause. That defendant is awarded costs in the sum of $75, and execution is hereby issued. Therefore, a 10-day stay is granted. The following memorandum and any supplemental memorandum made and filed by this court, support of this judgment, is hereby made a part hereof by reference by the court, dated December 9, 1968, with Martin B. Mahoney, Justice of the Peace of Credit River Township in Scott County, Minnesota. The memorandum. The issues in this case were simple. There was no material dispute on the facts for the jury to resolve. Plaintiff admitted that it, in combination with the Federal Reserve Bank of Minneapolis, which are for all practical purposes because of their interlocking activities and practices, and both being banking institutions incorporated under the laws of the United States, are in the law to be treated as one and the same bank, did create the entire $14,000 in money or credit upon its own books by bookkeeping entry. That this was the consideration used to support the note dated May 8, 1964, and the mortgage of the same date. The money and credit first came into existence when they created it. Mr. Morgan admitted that no United States law or statute existed which gave him the right to do this. A lawful consideration must exist and be tended to support this. Note C. Anheuser-Busch Brewing Company versus Emma as EMMA Mason, 44 MINN, I assume that's Minnesota, 318, 46, capital N, W, 558. The jury found there was no lawful consideration, and I agree, only God can create something of value out of nothing. Even if the defendant could be charged with waiver or estoppel as a matter of law, this is no defense to the plaintiff. The law leaves wrongdoers where it finds them. See section 50, 51, and 52 of am.jur, assuming this is start second 2D, actions on page 584. No action will lie to recover on a claim based upon, or any manner depending upon, a fraudulent, illegal, or immoral transaction or contract to which plaintiff was a party. Plaintiff act of creating credit is not authorized by the Constitution and laws of the United States. It is unconstitutional and voided. It is not a lawful consideration in the eyes of the law to support anything or upon which any lawful right can be built. Nothing in the Constitution of the United States limits the jurisdiction of this court, which is one of original jurisdiction with rights of trial by jury guaranteed. This is a common law action. Minnesota cannot limit or impair the power of this court to render complete justice between the parties. Any provisions in the Constitution and laws of Minnesota which attempt to do so are repugnant to the Constitution of the United States and are void. No question as to the jurisdiction of this court was raised by either party at the trial. Both parties were given complete liberty to submit any and all facts and law to the jury, at least insofar as they saw fit. No complaint was made by the plaintiff that plaintiff did not receive a fair trial. From the admissions made by Mr. Morgan, the path of duty was made direct and clear for the jury. Their verdict could not reasonably have been otherwise. Justice was rendered completely and without denial, promptly and without delay, freely and without purchase, comparable to the laws and the courts on December 7, 1968. By the court, December 9, 1968. Martin B. Mahoney, Justice of the Peace, Credit River Township, Scott County, Minnesota. On January 6, 1969, this court filed a notice of refusal to allow appeal with the clerk at the district court, Hugo L. Hentges, Hentges, for the county of Scott in the state of Minnesota, which is as follows. Notice of refusal to allow appeal to Hugh L. Hentges, clerk of district court, plaintiff, First National Bank of Montgomery, and defendant Jerome Daly. You will please take notice that the undersigned Justice of the Peace, Martin B. Mahoney, hereby pursuant to law, refuses to allow the appeal in the above entitled actions and refuses to make an entry of such allowance in the undersigned docket. The undersigned also refused to file in the office of the clerk of the district court in Scott County, Minnesota. A transcript of all these entries made in my docket, together with all process and other papers relating to this action, filed with me as a Justice of the Peace. The undersigned concludes and determines that MSA 532.38 was not complied with within 10 days after entry of judgment in my Justice of the Peace Court subdivision. 4. Thereof requires that $2 shall be paid within 10 days to the clerk of district court for the use of justice before whom the cause was tried. 2 so-called $1 Federal Reserve notes issued by the Federal Reserve Bank at San Francisco, L1278283C, and Federal Reserve Bank of Minneapolis, serial number 18041C6978, were deposited with the clerk of the district court to be tendered to me. These Federal Reserve notes are not lawful money within the contemptuation of the Constitution of the United States and are null and voided. Further, the notes on these faces are not redeemable in gold or silver coin, nor is there a fund set aside anywhere for the redemption of said notes. However, this is a determination of a question of law and fact by the undersigned pursuant to the authority vested in me by the Constitution of the United States and the Constitution of the State of Minnesota. Plaintiff is entitled to be awarded full due process of law before the court in this present determination not to allow the appeal. A plaintiff will file a brief on the law and facts with this court within 10 days, or a plaintiff will file an application for a full and complete hearing before this court on the determination. A prompt hearing will be set, and a plaintiff can satisfy this court that said notes are lawful money issued and pursuant under the authority of the Constitution of the United States of America. The undersigned will stand ready and willing to reverse himself in this determination. Take notice and govern yourselves accordingly by the court dated January 6, 1969 by Martin B. Mahoney. Martin B. Mahoney, Justice of the Peace, Credit River Township, Scott County, Minnesota. Memo. I am bound by oath to support the Constitution of the United States and laws passed pursuant thereto and the constitutional laws of Minnesota, not in conflict therewith. This is an important case to both parties and involves issues apparently not previously decided before. It is also important to the public. The clerk of the district court is an officer of the judicial branch of the state of Minnesota. His act is the act of the state. U.S. Constitution, Article 1, Section 10 provides no state shall make anything but gold and silver coin a tender in payment of debts. So let me say this right here before I want to interject. This is my viewpoint. So what he's saying here, what we're seeing here, the Article 1, Section 10, no state shall make anything but gold and silver coin a tender in payment of debts. So if someone's got the courage to take this to the court somewhere, they can do this because, frankly, we're not obeying this. If this is the so-called Constitution for this United States, in reality, simply is all these things that have happened back in the 1900s when they allowed a Federal Reserve Bank, which is not a federal bank, not a reserve bank, and is not even a bank. That is, it's a private bank, which is actually a warehouse, as they would say in some ways. It would be a great case for someone who had the guts to deal with this. It would be an opportunity to bring this whole system down. If there was a good lawyer out there, you could see this. The tender of the 2 Federal Reserve notes runs counter to the fundamental law of the land. It's right, fundamental law of the land. The Constitution of the United States of America. It appears on the face of it that the notes are ineffective for any purpose and that I am not justified in taking any steps towards the allowance of appeal in this case. It is, however, the order of this court that the parties are entitled to a full hearing before this court, and is, if requested, a full hearing will be granted. Dated January 6, 1969, by the court, Martin B. Mahoney. Minnesota statutes annotated 532.38 required that the appellate, that is the First National Bank of Montgomery, deposit with the clerk of the district court within 10 days $2 lawful money of the United States for payment to the justice of the peace before whom the cause was tried. This is one of the conditions for allowance of appeal. The two $1 bill, that is Federal Reserve notes, for deposit with the clerk of the district court, one issued by the Federal Reserve of San Francisco. I already mentioned the bearings of the serial numbers, and the other one from Bank of Minneapolis. The court determined that said notes on their face were contrary to Article 1, Section 10 of the Constitution of the United States. So not only is this simply thing about the bank that created the money out of nothing and then gave a mortgage, it's important. But what he's saying here also, Mahoney's saying, this is not lawful money. Hello? It's not. Someone at least has some fucking guts to do that. He did. He paid for it with his life, folks. He did. And this is a case. This is a case law set. If a lawyer has the guts of someone to deal with this, they could actually deal with this and begin to get the ball rolling in some ways to actually allow us to be free from this enormous servitude to the private bankers. So this again, let me continue on. I got to cut off the note here. The notes were without any lawful consideration, therefore were void. However, this court indicated it would give the plaintiff, that is First National Bank of Montgomery, a full and complete hearing with reference to this issue. No hearing was requested by plaintiff, that is the First National Bank. The court was ordered to show cause before the district court. The order to show cause is as follows. The district court state of Minnesota, County of State, First Judicial District, First National Bank of Montgomery, Minnesota was the plaintiff. Jerome Daly was the defendant. Order to show cause. On reading the application for order attached hereto and on motion to affidavit of Theodore R. Melby, attorney for plaintiff, due showing having been made that EXIG agency exists. It is ordered that Martin B. Mahoney, Justice of the Peace, Credit River Township, County of Scott, State of Minnesota, appear in person before the above court at 10 a.m. Friday, January 17, 1969, as a special term of court of Scott, State of Minnesota, as soon thereafter as counsel can be heard to show cause what he should not file in the office of clerk of district court. First Judicial Court, County of Scott, State of Minnesota, a transcript of all the entries made in this docket, together with all the process and other papers relating to the above, cause of the actions in his possession of any other justice of the peace of the state of Minnesota. Let this order, application for order, affidavit, all heretofore attached, be served on Martin B. Mahoney by leaving with him copies of the same as in this original order with the signature of the judge of district court hereto, a fixed service to be made forward. Dated at, I don't know how to pronounce this town, it's Shakopee, Minnesota, the 8th day of January 1969. By the court, Harry E. Flynn, Judge of District Court. Therefore, upon the motion of defendant Jerome Daly, this court ordered the hearing before the court of January 22nd, 1969 at 7 p.m. The First National Bank of Montgomery made no appearance, although service of the motion order was served upon Ralph Hendrickson, as Hendrickson, as its cashier on January 20th, 1969. No continuance was requested by plaintiff or his attorney. The defendant appeared by and on behalf of himself after waiting for more than 1 hour. After waiting for 1 hour for the bank or its representative to appear, the court received a testimony of the defendant bearing upon the issue of the validity of the Federal Reserve notes. Now, therefore, based upon all the files, records, and proceedings herein, and the evidence offered, this court makes the following finding of fact. Conclusion of law, judgment, and determination with reference to the allowance of appeal. Finding of fact, conclusions of law, judgment, and determination. that the Federal Reserve Banking Corporation, the United States corporation with 12 banks thereof, that is throughout the United States, including New York, Minneapolis, and San Francisco, that the First National Bank of Montgomery is also a United States corporation incorporated and existing under the laws of the United States and is a member of the Federal Reserve System and more specifically of the Federal Reserve Bank of Minneapolis. That because of the interlocking control activities, transactions, and practices, the Federal Reserve Bank and the National Bank are for all practical purposes in the law one and the same bank. So what I want to share with you, what I just shared here, that the plaintiff did not show up, it meant simply is they failed to show up, so it became a ruling, period. That's what it meant, okay? I meant to say that. Article 3 here. As evidence from the book, The Federal Reserve System, Its Purpose and Function, the first edition, page 74 to 78, 177 and 180, put out by the Board of Governors of the Federal Reserve System, Washington, D.C., 1963, and from other evidence adduced herein, the said Federal Reserve banks and national banks created money and credit upon their books and exercised the ultimate prerogative of expanding and reducing the supply of money or credit in the United States. See especially page 75 of the manual. This creation of money or credit upon the books of the bank constitutes the creation of fiat money by bookkeeping entry. It's there. It's all here. 90% or more of the credit never leaves the books of the banks, as the banks produce no species as banking. When the Federal Reserve banks and National Bank acquired United States bond and securities, state bonds and securities, state subdivision bonds and securities, mortgages on private real property, and mortgages on private personal property, the said banks create the money and credit upon their books by bookkeeping entry. You see, there's no honesty in this, folks. The first time that money comes into existence is when they create it on their bank books by bookkeeping entry. Banks create it out of nothing. No substantial fund of gold or silver is backed of it, or any fund at all, period. The mechanics follow in the acquisition of United States bonds are as follows. The Federal Reserve Bank places its name on a United States bond and goes to its banking books and credits the United States government for an equal amount of the face value of the bonds. The money or credit first comes into existence when they create it on the books of the bank. National Bank do the same, except they must have $1 in credit on hand for every $4 they create. The Federal Reserve Bank of Minneapolis obtained Federal Reserve notes in denominations of $1 bill, $5 bills, $10 bills, $20, $50, $100, $500, $1,000, $10,000, and $100,000 for the cost of printing of each note, which is less than 1 cent. The Federal Reserve Bank must deposit with the Treasury of the United States a like amount of bonds for the notes it receives. The bonds are without lawful consideration, as the Federal Reserve Bank creates the money and credit upon their books by which they acquire the bond. With their bookkeeping created credit, the national banks obtain these notes from the Federal Reserve banks. The net effect of the entire transaction is that the Federal Reserve Bank and the national banks obtain Federal Reserve notes comparable to the ones they placed on file with the clerk of district court, and the specimen of which is above for the cost of printing only. Title 31, USC, Section 462, 392, in parentheses. Attempts to make Federal Reserve notes a legal tender for all debts, public and private, see page 72. From 1913 down to date, the Federal Reserve banks and the national banks are privately owned. As of March 18, 1968, all gold backing was removed from the said Federal Reserve notes. No gold or silver backs up these notes. The Federal Reserve notes in question in this case are unlawful and void upon the following grounds. Said notes are fiat money, not redeemable in gold or silver coin upon their face, not backed by gold or silver, and the notes are in want of some real or substantial fund being provided for payment and redemption. There is no mode provided for enforcement the payment of the same. There is no mode provided for the enforcement of the payment of the notes in anything of value. The notes are obviously not gold or silver coins. The sole consideration paid for the $1 Federal Reserve notes is the neighborhood of 9/10 of 1 cent, Therefore, there is no lawful consideration behind said notes. Number 4, that said Federal Reserve notes do not conform to Title 12 United States Code, Section 411, 418, Title 31 USC, Section 462, in parentheses 392. Insofar as it attempts to make Federal Reserve notes and circulating notes of the Federal Reserve Bank and National Bank Association a legal tender for all debts, public and private, it is unconstitutional and void, being contrary to Article 1, Section 10 of the Constitution of the United States, which prohibits any state from making anything but gold and silver coin a tender or impairing the obligation of contracts. Now, therefore, by virtue of the authority vested in me pursuant to the Declaration of Independence, the Northwestern Ordinance of 1787, which is what it's supposed to be, the Constitution of the United States of America, and the Constitutions of the State of Minnesota. Here, it is hereby determined, ordered, and adjudged that the appeals statutes of the State of Minnesota for civil appeals from the court to the district court is not complied with within 10 days after entry of judgment. Therefore, the appeal is not allowed by this court, and my docket so shows. Dated February 5th, 1969, by the court by Martin B. Mahoney. Memorandum. Division and separation of the three great powers of government, the executive, the legislature, and the judicial, and the principles that these powers should be forever kept separate and distinct as of vital importance to the maintenance and establishment of a free government, without which this republic cannot possibly survive. The particular wording of the Declaration of Independence was set up a obsolete cutoff with the British form of government is contained in the first two paragraphs thereof. Thereafter, the Constitution was attained and established as a law for the government by the people of the United States. All legislative power granted or vested in the Congress of the United States, consisting of a House of Representatives and a Senate elected as representative of all the people. Judicial power is defined in Black's Law Dictionary as the authority vested by courts and judges, as distinguished from the executive and the legislative power. Cases and controversy is defined in Black's Law Dictionary. This term is used in the Constitution of the United States. Embraces claims or contentions of litigants brought before the court for adjudication by regular proceeding for the protection of wrongs. And whenever the claim of contention of a party takes such a form that the judicial power is capable of acting upon it, it has become a case or controversy. See Interstate Commerce Commission versus Brinson, 154 U.S. 447 14 SUP CRT. I assume that's the Supreme Court. 1125, 38 Law ED 1047 Smith versus Adams 130 U.S. 1679 32 L.ED.895. Under one form of government, every American, individually or by representation, is the high and supreme sovereign authority. The authority of each of these three departments of government is defined and established. It is entirely fitting and proper to observe that in all instances between the states and the United States and the people, there is no such thing as the idea of a compact between the people on one side and the government on the other. The compact is that of the people with each other to produce and constitute a government. To suppose that any government can be a party to a compact with the whole people is supporting it to have existence before it can have a right to exist. The only instance in which a compact can take place between the people and those who exercise the government is that the people shall pay them while they choose to employ them. Interesting. A constitution is the property of the nation, and more specifically of the individual, and not those who exercise the government. All the constitutions of America are declared to be established in the authority of the people. The authority of the Constitution is grounded upon the absolute God-given free agency of each individual. This is the basis of all powers granted, reserved, or withheld, the authorization of every word, phase, clause, or paragraphs of the Constitution. Any attempt by Congress, the president or the courts to limit, change, or enlarge even the most claimed insignificant provision is therefore ultra vires and void ab initio. When considering the United States Constitution, one must absolutely and completely clear his mind of all British monarchy, papal, clergy, continental, financial, or any other alien influences or conceptions of government, the rights of the individual, and what is constitutional. Our Constitution stands absolute and alone. It must be read in the light of all engagements entered into being before its adoption, including the Declaration of Independence and the privileges and immunities secured by the common law, confirmed by Magna Carta and other English charters, accepting therefore all clerical, papal, and monarchy nonsense. No one applying the Constitution to any situation has any business, right, or duty to look in any direction for sovereignty but towards the people. Wow. Any attempt or inclination to do so is a violation of one's oath and continues duty to uphold, maintain, and support the Constitution of the United States of America. See Waring, W-A-R-I-N-G versus Mayor of Savannah, 60 Georgia, page 93, where it is quoted as follows. In this state, as well as all republics, it is not the legislator, however transcendent powers, who are supreme, but the people. And this is why we are in a mess, folks, because people have backed down. They don't know who they are. You are the authority, folks. You are that authority. Pick up the ball. But the people and the support suppose that they may violate the fundamental law is, as has been most eloquently expressed, to affirm that the deputy is greater than his principal, that the servant is above his master, that the representatives of the people are superior to the people themselves, that men acting by virtue of delegated power may do not only what their powers do not authorize, but what they forbid. The law is made by the legislature, but applied by the courts. See General Mr. Justice Story Commentaries on the Constitution found in Story on the Constitution, Volume 1, Section 198 through 280, on the history of the Revolution and the Confederation, origin of the Confederation, analysis of the Articles of Confederation, and the decline and fall of the Confederation, including the reasons for it, which in chief was a debasement of our money and currency by the banks, similar to what is taking place in our country today. For authorities to support the proposition that an act of Congress is violation of the Constitution confers no rights or privileges, see 16 AM, I assume that's American jurisdiction, 2D, constitutional law, section 177 through 179. Article 1, section 10 of the United States Constitution provides that no state shall make anything but gold and silver coin a legal tender in payment of debts. The act of the clerk of the district court is the act of the state. The clerk of the district court is the agent of the judicial branch of the government of the state of Minnesota. See Briscoe L. versus the Bank of Commonwealth in Kentucky. Levin Peters reports at page 319. A state can act only through its agents, and it would be absurd to say that any act was not done by a state which was done by its authorized agents. For the justice fees, bank deposit with the clerk of district court, the 2 Federal Reserve notes. The clerk tendered the notes to me. My sworn duty compelled me to refuse to tender. This is contrary to the Constitution of the United States. The states have no power to make bank notes a legal tender. See 35, America Jurisdiction on Money, Section 13. Only gold and silver coin is a lawful tender. See also 36 AM JUR on Money, Section 9. Banknotes are a good tender on money unless specifically objected to. Their consent and usage is based upon the convertibility of such notes to coin and the pleasure of the holder upon presentation to the bank for redemption. When the inability of a bank to redeem its notes is openly avowed, they instantly lose their character as money and their circulation as currency ceases. There is also no lawful consideration for these notes to circulate as money. The banks actually obtain these notes for the cost of the printing. There is no lawful consideration for said notes. A lawful consideration must exist for these notes to circulate as money. The banks actually obtain these notes for the cost of the printing. There's no lawful consideration for said notes. A lawful consideration must exist for a note. See 17 American JUR 2D on contracts, Section 8.5, and also Section 215, 216, and 217 of 11 AMR.JUR. Second on bills and notes. As a matter of fact, the notes are not notes at all, as they contain no promises to pay. The activity of the Federal Reserve Bank in Minneapolis, San Francisco, and the First National Bank of Montgomery is contrary to public policy. It should be public law, but in reality, simply what's happened is simply it's become public policy after the Franklin Delano Roosevelt deal. And the Constitution of the United States and Constitution unlawful creation of money and credit is not warranted by the Constitution of the United States. It's not. The Federal Reserve and national banks exercise the exclusive monopoly and privilege of creating credit and issuing their notes at the expense of the public, which does not receive a fair equivalent. This scheme is of liberty designed for the benefit of an idle monopoly to rob, blackmail, and oppress the producers of wealth. The Federal Reserve Act and the National Bank Act, as is in operation, in fact, contrary to the whole letter and spirit of the Constitution of the United States, confers an unlawful and unnecessary power on private properties, on private parties, holds all of our fellow citizen independence, in subversion to the rights and liberties of the people. It has defied the lawful constituted government of the United States, the Federal Reserve and the National Banking Acts, and SEE 462 in brackets 392 of Title 31 of USC are not necessary and proper for carrying into execution the legislative powers granted to Congress or any other powers vested in the government of the United States, but on the contrary are subversive to the rights of the people and their rights to life, liberty, and property. The aforementioned acts of Congress are unconstitutional and void, and I so hold. The meaning of the constitutional provision, no state shall make anything but gold and silver coin a tender in payments of debts, is direct, clear, unambiguous, and without any qualifications. This court is without authority to interpolate any exception. My duty is simply to execute it as written and to pronounce the legal results. From examination of the case of Edwards versus Kersey, I'll spell that for you, Kearzeb 96 US 595. The Federal Reserve notes, that is fiat money, which are attempted to be made a legal tender, are exactly what the authors of the Constitution of the United States intended to prohibit. No state can make these notes a legal tender. Congress is incompetent to authorize a state to make the notes a legal tender. For the effect of binding constitutional provisions, see Cook, C-O-O-K-E, versus Iverson, I-V-E-R-S-O-N, 108 M.388, and State versus Sutton, 63 M.147, period. This fraudulent Federal Reserve System and national banking system has impaired the obligation of contract, promoted disrespect for the Constitution and law, and has shaken society to its foundations. The court is at loss because of the non-appearance of a plaintiff to determine upon what legal theory plaintiff could possibly claim that the notes in question are legal tender. If they had any validity, it must come from the Constitution of the United States and laws passed pursuant thereto. That is, inquiry was made to Mr. Daly as to what laws these notes could be possibly based upon, sustain their validity. To aid the court, he presented the following: Section 411, 412, 417, 418, 420 of USC Title 12 and Title 31 USC SEC 462 and in brackets 392. On the one hand, Section 411 holds and states that the notes are to be used for the purpose of making advances to Federal Reserve banks through Federal Reserve agents, and for no other purpose than Title 31, Section 462, 392 in brackets states, all Federal Reserve notes and circulating notes of Federal Reserve banks and National Banking Association heretofore or hereafter issued shall be legal tender for all debts, public and private. So this is a title, this is a statute, okay? So it's not dealing with the Constitution, it's the statute. Okay. But he continues to refer this, okay? If the Constitution is the law of the land, he states, the Constitution states again, no state shall make anything but gold and silver coin a legal tender in payments of debts. The above referred to enactments of Congress state that the notes are legal tender. There is direct conflict between the Constitution and the acts of Congress, folks. If the Constitution is not controlling, then Congress is above and has superior authority from the Constitution and the people who ordained and established it. Yeah, right, correct. Title 31 USC, comma, section 462, brackets 392. It is in direct conflict with the Constitution insofar as at least that it attempts to make Federal Reserve notes a legal tender. The Constitution is the supreme law of the land. Section 462, brackets 392. Is not a law which is made in pursuant of the U.S. Constitution. It is unconstitutional and void, and I so hold. Therefore, the two Federal Reserve notes are null and void for any lawful purpose. So far as this case is concerned, are not a valid deposit of $2 with the clerk of district court. I hold that the case has not been lawfully removed from the court. The jurisdiction thereof is still vested in the court. However, there is a second ground invalidated of these Federal Reserve notes, previously discussed. That is, the notes are invalid because on the no theory are they based upon valid adequacy of lawful consideration. At the hearing scheduled for January 22nd, 1969 at 7 p.m., Mr. Morgan, nor anyone else from or representative of the bank, attempted to aid the court in making a correct determination. Mr. Morgan appeared on the trial, that is December 7th, 1969, and appeared as a witness to be candid, open, direct, experienced, and truthful. He testified to 20 years of experience with the Bank of America in Los Angeles and the Marquette National Bank of Minneapolis, and the plaintiff in this case. He seemed to be familiar with the cooperation of the Federal Reserve System. He freely admitted that the bank created all the money or credit upon its books with which it acquired a note and mortgage on May 8, 1964. The credit first came into existence when the bank created it upon its books. Further, he freely admitted that no United States law gave the bank the authority to do this. There was obviously no lawful consideration for the note. The bank parted with absolutely nothing except a little ink. In this case, the evidence was on January 22nd, 1969. The Federal Reserve banks obtained the notes for the cost of the printing only. This seems to be confirmed by Title 12 USC Section 420. The cost is about 9/10 cents per note. Regardless of the amount of the note, the Federal Reserve Bank created all the money and credit upon their books by bookkeeping entry by which they acquired United States and state securities. The collateral required to obtain the notes is by Section 412 USC, Title 12, a deposit of a like amount of bonds. Bonds which the bonds acquired by creating money and credit by bookkeeping entry. No rights can be acquired by fraud. The Federal Reserve notes are acquired through the use of unconstitutional statutes and fraud. The common law requires a lawful consideration for any contract or note. These notes are void for failure of a lawful consideration at common law, entirely apart from any constitutional consideration. Upon this ground, the notes are ineffective for any purpose. This seems to be the principal objection to paper fiat money and the cause of its depreciation and failure down through the ages. If allowed to continue, the Federal Reserve notes will meet the same fate. From the evidence introduced in January 22nd, 1969, this court finds that as of March 18, 1968, all gold and silver banking is removed from Federal Reserve notes. The law leaves wrongdoers where it finds them. See 1AMR.JUR, second on actions, section 50, and 51 and 52. The court further observes that the jurisdiction of the court is conferred by Article 6, Section 1 of the Minnesota Constitution. Section 1, judicial power of the state is hereby vested in the Supreme Court, a district court, a probate court, and such other courts, minor judicial officers and commissioners with jurisdiction inferior to the district court as the legislator may establish. Pursuant thereto, an act of the legislator credited this court. Nothing on the Constitution or laws of the United States limits the jurisdiction of the courts. The Constitution of Minnesota does not limit the jurisdiction of this court. It therefore has complete jurisdiction to render justice in this cause in accordance with and agreeable to the supreme law of the land. See 16 AM JUR 2D on Constitutional Law, Section 210 through 222. When a court is created by act of legislation, the judicial power is conferred by the Constitution and not by the act creating the court. If the jurisdiction is to be limited, it must be limited by the Constitution. See Minnesota Constitution Bill of Rights. In any event, the bank has not raised any question as to the jurisdiction of this court. Slavery and all its incidents, including, I don't know how to pronounce this, I'm going to say this, peonage, I'm going to say Peonage, Thralldom. I don't know if that's a misprint, and debt created by fraud is universally prohibited in the United States. This case represents but another refined form of slavery by the bankers. Their position is not supported by the Constitution of the United States. The people have spoken their will in terms which cannot be misunderstood. It is indispensable to the preservation of the union and independence and liberties of the people that this court adheres only to the mandates of the Constitution and administration. It is as written. I therefore hold the notes in question void and not effective for any purpose. January 30 of 1969. Martin B. Mahoney. Martin B. Mahoney, Justice of the Peace, Credit River Township, Scott County, Minnesota. Note, defendant, that is the attorney Jerome Daly, shortly after the above court declared the above decision, again brought the issue of Federal Reserve notes before the court. On appeal to a federal court, the federal judicial officers probably ridiculed Mr. Daly for challenging the validity of the notes of the Federal Reserve Bank, and Mr. Daly disbarred from practicing law. This is United States versus Jerome Daly, 481 F2D 28 in brackets. This act of our federal judicial officers to disbar a federal member of the bar for question the validity of the monetary system of the United States raises the question as to who the federal judicial officer are employed by. It is obvious that they are employed by the international banking cartels, not the people of the United States, and not the people of the United States is in all caps. Minnesota State Board of Law Examiners. What follows is the testimony of Ronald D. Granholm, Vice President and General Counsel of the Federal Reserve Bank of Minneapolis, taken Wednesday, February 11, 1970, in disbarment proceedings brought by the Minnesota State Board of Law Examiners against Jerome Daly to have Mr. Daly disbarred from the practice of law. This testimony was taken under oath. Wednesday, February 11, 1970, approximately 2:30 p.m., whereupon the following procedures were duly had. Wow. Continue on here. This is the most important information out here, folks. Whereupon the following procedures were duly had. Mr. Ronald D. Graham, being first duly sworn, testified as follows on behalf of the petitioner. Testimony solicited by Mr. Davis, attorney for the petitioner. Will you state your full name, please? And he says that I am Ronald D. Graham. Tells his name. Your address, Mr. Graham. My address is 73 South 5th Street, Minneapolis, Federal Reserve Bank of Minneapolis. What is your profession? I am an attorney. By whom are you employed? I am Vice President General Counsel of the Federal Reserve Bank of Minneapolis. Are you licensed to practice law in the state of Minnesota? Yes, sir. For how long a time have you been counsel for the Federal Reserve Bank of Minneapolis? I have been General Counsel for the Federal Reserve of Minneapolis since 1966. However, I was on the staff of the legal department of the bank since 1959. In the course of your duties with the Federal Reserve Bank of Minnesota, have you had occasion to be involved in litigation with Mr. Jerome Daly? He said, yes. Have you received any inquiries from other agencies of government or other persons within the banking group concerning these actions commenced by Mr. Daly? Well, we received several inquiries with respect to the actions commenced against our bank, and especially by other Federal Reserve banks and the Board of Governors. We kept them constantly informed of the progress in these cases as it occurred. And there was an occasional inquiry made with reference to these cases from our office. Yes. Do you have any compilation? Do you have any compilation of lists or inquiries that were made either to you or to the board, the Federal Reserve Board? I have a compilations of inquiries that were made and letters sent out by the Board of Governors and the Treasury Department, which refers to a case arising in Clever River, Minnesota, involving the constitutionality of the Federal Reserve System. You have that letter with you. Whereupon petition exhibit 66 and 67 were duly marked for purpose of identification. I show you petition exhibit number 66, which identified that for the court. This is a letter dated September 2nd, 1969, addressed to me from Mr. Robert Sanders, Assistant General Counsel of the Board of Governors of the Federal Reserve System. And Mr. Sanders sent me this list at my request, in which it contains a list of numbers of response made by the Board of Governors and Treasury Department in connection with inquiries received by them, certain congressional offices relating to a case arising out of Credit River, Minnesota, and arising as a result of a publication, primarily of a publication distributed reporting this case entitled Myers, MYERS, Financial Review. And I show you petition exhibit 67 and ask you to identify that. This is a subsequent Xerox copy of some articles that were referred to in that letter, which also were the basis of inquiry that we received. Cross-examination. Mr. Jerome Daly, cross-examination consists of two arguments. The first part of his argument was to elicit confirmation from Mr. Ronald D. Graham as a qualified spokesman for the Federal Reserve Bank that the Federal Reserve Bank and commercial banks do create deposit checkbook money on their books as their lending and investing money medium. The second part of Mr. Daly's argument was the convertibility of the pocket paper currency into gold or silver. It's a separate argument and irrelevant to the mechanics of deposit, that is the checkbook money creation. Therefore, to make it easier for the reader to understand the mechanics of where and how bank deposits, that is checkbook, and then money, generally referred to as credit, is created. All questions and answers referring to currency convertibility are edited, left out. Testimony solicited by Jerome Daly. You say you have been with the Federal Reserve Bank for how long? 10 years, approximately 10 years. And you are a vice president of the bank? Yes, sir. And you say that you have been in the practice of law in the state of Minnesota? Yes, sir. And also in the United States District Court? Yes, sir, for the state of Minnesota. Whereupon Respondent Exhibit J was duly marked for purposes of identification. Showing you Respondent Exhibit J, and I will ask you if you can identify that. Answer. Respondent Exhibit J is a publication put out by the Board of Governors of the Federal Reserve System displaying its purpose and function. Question. And what issue is that? According to this is the issue that was published in 1963. Question. Are you familiar with that? Respondent's Exhibit J. I am familiar with this publication. I could not cite it, all the language, but I am familiar with this publication. Have you looked it over? Yes. Generally, do you agree that the statements in there are true as to the function? I'm sorry. Generally, this is the question. Generally, do you agree that the statements in there are true as to the functions and so forth? Yes, sir. That is the official publication of the Board of Governors. Is it not true? Yes. So I want to point out here as I continue to share with you, Mr. Daly is not an attorney here. He's doing this on his own. Okay, he's asking questions to find out the truth. Got a lot of guts. Okay, plenty of guts. Mr. Daly, I offer in evidence Exhibit J. Mr. Davis, no objection. The court, it will be received. Now, your Federal Reserve banks, there are 12 of them in the United States, aren't there? That is correct. And more or less, the head bank is in New York, is it not? There's a Federal Reserve Bank of New York that represents a second Federal Reserve district. It is a separate incorporated bank, separate from the other 11 banks. Yes. Now, by the way, these Federal Reserve banks have employees, do they not? Yes, they do. And there are none of these employees on civil service? No, sir. That is a true statement, is it not? Yes, sir. You're not on the civil service yourself? No, sir. And the Federal Reserve banks pay taxes to the state for the real estate they are situated upon? Yes, sir. And the Federal Reserve banks are owned by the member banks, are they not? I don't know what you mean by own, Mr. Daly. Question, I withdraw the question. The Federal Reserve Corporation is a corporation organized and existed by virtue of the laws of the United States. Is that correct? That is correct. And the member banks are required to subscribe to so much stock. That is correct. But this is not a non-voting stock. Is that correct? They have a right to elect 6 of the directors of the Federal Reserve Bank. Okay, question. I didn't mean that it is a stock that doesn't actually carry any rise to ownership with it, isn't it? Isn't that correct? The Federal Reserve stock owned by member banks of Federal Reserve System, representing the capitalization put into the system required by law, it gives them certain limited rights as to the election of directors on the board of the reserve banks. However, in the event of dissolution of any Federal Reserve Bank, they are only entitled to their reserves, the amount of capitalization they have put into the reserve bank. and it's after the Reserve Bank has paid all the liabilities and expenses, all the residues go into the United States government. Question. As the members banks like the First National here in Minneapolis, Northwestern National, they have a right to use the services of the Federal Reserve Bank? Yes, we do provide services for them. Yes. And the First National Bank of Montgomery is one of your member banks? Yes, sir. Question. Now calling your attention to page 75 in that book. Will you read the last two paragraphs out loud? Last two paragraphs. Answer. I think that is what I want. The commercial banks, this is the answer, the commercial banks as a whole can create money only if additional reserves are made available to them. The Federal Reserve System is the only instrumentality endowed by law with discretional powers to create or extinguish the money that serves a bank reserves or as public pocket cash. Pocket, can't even get the word out, pocket cash. Thus, the ultimate capacity of expending and reducing the economy supply of money rests with the Federal Reserve. New Federal Reserve money, when it is not wanted by the public for hand-to-hand circulation, becomes the reserves of member banks after it leaves the hands of the first bank acquiring it, as explained above. The new reserve money continues to expand into deposit money as it passes from bank to bank until deposits stand in some established multiply of the additional reserve funds that Federal Reserve action has supplied. Question. Now, the mechanics. Can you explain the mechanics by which the Federal Reserve Bank runs its open market committee? Runs its open market committee. Question. Yes. The open market committee is not a committee of the Federal Reserve Bank, Mr. Daly. It consists of 7 members of the Board of Governors of the Federal Reserve System and 5 of the 7, that is 5 of the 12 presidents of the Federal Reserve Banks. Question. And the 7 members of the Board of Governors? Yes, sir. Will you explain to the court what their function is? Answer. The function of the Federal Open Market Committee is to meet and make policy with reference to purchase or sale of government securities by Federal Reserve banks. Now, can you elaborate on that? That's the question. The purchase and sale of government securities by Federal Reserve banks under direction of the Open Market Committee is a device, one of monetary tool used by the Federal Reserve System to expand on one of the Federal Reserves. Expand or reduce the reserves? Yes. Now, does the Federal Reserve Bank expand its reserves? That's the question. The reserves of the commercial banks? He's asked answer. Or is it own reserves? The action is taken, now here's his answer. The action taken with reference to the Open Market Committee and expansion of the commercial bank reserves that are required to be held in the Federal Reserve banks in their own vault by expanding reserves of the commercial banks. This then takes out of circulation or the ability of commercial banks to expand loans or investments. Question. So that 7 members of the Board of Governors and the 12 presidents of the Federal Reserve Bank have the control over the volume of credit that is made available to the public. Answer. The Open Market Committee, which consists of 5 of the 12 presidents of Federal Reserve banks and the 7 members of the Board of Governors, directs policy with reference to the sale or purchases of government securities on the one open market, which expands or contracts the ability of commercial banks to make loans and investments. Question. This has a direct bearing upon the amount of money that is available to the public. It would have a direct bearing on the amount of money and supply of credit available. That's his answer. Now, question. The Federal Reserve Bank actually creates credit on its books, does it not? The answer. The only way in which it creates credit is by its discount policy, in which it may credit by making a temporary loan and credit the reserve accounts of that individual bank. Question. It can credit the account of the individual bank by making a loan to the bank? Yes, sir. This is a loan that is repaid. Question. And when the Federal Reserve Bank makes the loan or that credit first comes in existence, it is when they manufactured it on the books. And his answer is, it is a credit to their reserve. And then the question is, and it first comes in existence at that time? His answer, these are temporary loans. His question again is, and it doesn't make any difference if it is temporary or long-term. The first time it comes into existence is when it is credited on the books of the bank. Yes, sir. Question on. As a practical matter, the credit never leaves the books of some bank. This is a question again, sorry. And as a practical matter, this credit never leaves the books of some bank. It's transferred by check entry from one bank to another. Answer. The effect of that particular transaction may or may not be transmitted through the banking system. I don't know. What answer? Question. What percentage of the volume of business was done by check in this country? I don't know the figure, Mr. Daly. I don't know the breakdown upon demand deposits and currency at the present time. Question. Now, when a member bank makes a loan, what is the percentage of so-called reserves that they are supposed to have on hand? Answer. That is determined by the Board of Governors of the Federal Reserve System and varies at what the board decides. What is it at present? Question. Is it kind of it's a multiple breakdown at present? Recollection of it. Let me start up. It's kind of a multiple breakdown at present. My recollection is reserves are 17% reserve requirement and 16% for the country banks, which are required to have a lower reserve. So here's the question. In other words, when, say, like the First National Bank of Montgomery wants to make a loan of $100, it has a reserve of $1,700 on deposit with our bank, it can make a loan of $100. Answer. If the Reserve Bank decides to lend it, yes, this is discretionary. Question. If the First National Bank decides to lend it, now, application for a loan, a discount from the Federal Reserve Bank may be made in discretion with the Federal Reserve Bank if it feels it is appropriate borrowing. Question. Does the First National Bank of Montgomery do they have to get the permission of the Federal Reserve Bank of Minneapolis before they can make a loan? Answer. They make application for a loan and it can be turned down at the Federal Reserve Bank and nonetheless did not deem it a good loan. To an individual, they only make loans and discounts to banks. I'm talking about the individual citizen that walks into the bank and wants to borrow $10,000 from the bank out in the country. He answers back, all right. So he's already beginning to pin him down here, folks. This guy knows what the shit he's doing. He knows what he's doing big time. He's understanding the whole system. Okay. Does that bank out in the country also create money on its books? Answer. That bank may make a loan to that individual if it has the funds available to make that loan. Question. Does that bank, that is the commercial bank, can also create credit on their books? To their extent, that reserve or equity at the position permits them to make a loan in accordance with their policy. They can do this by issuing a cashier check, which is liability in the bank, or do so by creating the deposit account of that individual. Question. To what extent can they do that? I guess I don't follow your question. Question, is there a limit upon them? Is there a limit to the extent that they can do that? Answer, the ultimate limit to which they would be restricted would be determined by the amount of reserves they are required to hold back, depending upon what the reserve requirements as established by the Board of Governors of the Federal Reserve System are. Question, so there is a percentage of limits? Yes. Question, they also create credit on their books? Answer, to the extent they can make loans or investments. Question, and this question first comes into being when they create it. Answer, when the credit is made to the account of the customer, they have thus created a loan to the customer in the form of a deposit balance. Now, this may be drawn upon to pay off perhaps creditors of the individual that is making the loan. Question, but in any event, this is for the first time that this credit comes in existence. They create it on their books. Yes. You see, keep on. So he continues to push. Question. So in effect, the books of the member banks amounts to a bill of credit, do they not? What is your definition of a bill of credit, Mr. Daly? Question. There has been some argument about that. Isn't that right? Yes. Question. But at any rate, the credit is manufactured on the books, though. Answer. There is a credit on the account of the customers. Either that is given in dispersed funds by means of a cashier check or some other. Question. Now, have you had a chance to read over my publication, The Daily Eagle? I don't remember if I have read it through or not, Mr. Daly. Have you attempted to read it? I believe I did read it at one time, but I don't recall all the language in it. Question. There's a picture of a note in here on page 12, a $1 Federal Reserve note. Yes, sir. Question. Is this a sample of what is in circulation? Answer. As currency? Yes, that is the question. It appears as though it is a Federal Reserve note. Yes, sir. Well, Question. Well, that is reasonable, accurate portrayal. Is that right? Yes. Question. Your bank acquires the United States obligations by creating credit on its books, do they not? Answer. I guess you might say by creating credit and permitting under the policy of the Federal Reserve. Yes. Continue on. Question. But the physical notes themselves, they are made up by the Bureau of Printing and the engraving, right? That is correct. Question. And that is under the control of what? The Treasury Department? I believe it is the Treasury Department. Answer. Question. The notes themselves, you get these notes in denomination from $1 up to $10,000. Is that right? Answer. I don't believe there is a $10,000 bill in circulation, but we get them in various denominations now permitted by law. Question. And your bank gets them for the cost of printing? Brilliant question. We get them, yes. These are the actual physical notes, yes, for the cost of printing, but they are issued as a liability on the Federal Reserve Bank and Minneapolis or whatever Federal Reserve Bank is involved. Well, now I believe you indicated that you had some correspondence from the head office of the Board of Governors of the Federal Reserve System. That was the question. Yes. Answer. With you for purpose of filing it to the Bar Association, is that right? Answer. This arose because I had heard that there was some testimony being given before the Ethics Committee with reference to the Credit River proceedings. I talked to Mr. ORREN with the Ethics Committee and indicated I had a number of telephone calls with respect to the Credit River proceedings, and I acknowledged that they had received a number of inquiries down in the border of the Treasury Department arising out of the Myers financial publication. Question. Is this Myers Financial Review? Yes. Question. From Calgary, Alberta, Canada? Yes, sir. Question. Do you ever see his review before today? Did you ever see his review before this? Before today, I've seen copies of a publication, I believe, that was dated May 27, 1969. Question. May 27, 1969? Yes, sir. Question. And this is the first publication in which he published it? Is that right? Published what? I'm sorry. Question. This story will reference to the Credit River verdict. Answer. I don't know, Mr. Daly. I just saw the May 27th issue. Whereupon Respondent Exhibit K was marked for purpose of identification. Question. Do you recognize that as a copy that you saw? Yes, sir. Question. And how soon after May 27 of 1969 did you see that? The only one I recollect was a publication that came out, I believe, in June. I don't subscribe to that publication. Well, it's fair to say that you gentlemen that are counsel for the Federal Reserve Banks and general counsel for the Board of Governors, you're keeping a very close tab on this dispute. Answer. Well, as a matter of information, yes and yes. Question. And you have since 1963? Answer. I have transmitted all the information down to the Board of Governors with reference to the suits. Yes. Question. By the way, the Board of Governors of the Federal Reserve System are independently controlled by Congress, are they not? And he speaks back, no, sir, that is not true. Well, can you elaborate on why it is not true? Answer. The Federal Reserve System was established by Congress and the Federal Reserve Act by legislated and enacted by Congress. That's his answer. But at the present time, Congress exercised no control over them. Answer. Are you talking about control over decisions, policy decisions made by the Federal Reserve? Right. That's the question. There is specific law I am aware that any congressman can effectual a policy decision upon the Federal Reserve. Question. That is what I'm driving at. Yes. Question. And the Board of Governors of the Federal Reserve System controls volumes of credit that is put into circulation? Answer. The policy decisions of the Board of Governors, that is Mr. Daly, influence the supply of money and credit in the country? Yes. I think that is a fair statement. Question. That under the present law is independent of any act of Congress? Answer. The policy decisions I'm aware of are not subject to any congressional mandate. That is correct. Wow. Continue. Question. And the determination of the interest rate is not subject to any congressional mandate. No, sir. I think the determination of the interest rate is a result of the marketplace. Are you talking about? Question. Action of the Open Market Committee? Interesting. Answer. Actions of the Open Market Committee could have an influence on the levels of interest rate. This guy knows his stuff. Question, isn't that set by basically, if it's set or controlled, that is the prime record, the prime rate is set and controlled by the board as a governor? Answer, the prime rate? No. Question, pardon me, no. What did they do with reference to the interest rate? Question, the only answer, the only interest rate I think you are referring to is a discount rate established by the Federal Reserve banks. The discount rate is established initially by the board of directors of Federal Reserve banks, subject to review and determination by the board of governors. This discount rate is the rate charged against member banks of the Federal Reserve System who make loans or discounts at Federal Reserve banks. Question, isn't it pure and simple the rate of interest that the Federal Reserve Bank charges the members bank for the credit that they create on their books? Answer, would you repeat that one? Yes. Question, to use simple language, isn't the rate of interest that the Federal Reserve Bank charges the member banks for credit they create on the books? Answer, this is for loans or advances given to member banks. Yes. Question, and these loans and advancements are created on the books of the Federal Reserve Bank. Answer, the making of a loan or discount is effective of a credit to the reserve account of a member bank. Question, when do they create the credit on their books? It comes in existence, that is. Answer, yes. Question, discount rate is set by the Board of Governors of the Federal Reserve System. Answer, the discount rate is initially set by the Board of Directors of Reserve Banks independently. They are subject to review and determination of the Board of Governors in the Federal Reserve System. Question, so if all of the member banks get together and agree to set the discount rate, which is the Federal Reserve banks get together and set the discount rate, the Board of Governors doesn't have anything to say about it. Answer, they have to approve a discount rate. Question, the people in charge of the Federal Reserve banks are not, none of them are government employees as such. Answer, of the Federal Reserve banks? Question mark. Yes, right. None of them are under civil service. No. Question, and none of them are government employees as such then? No, sir, they are not under civil service. Mr. Daly, I think that is all the questions I have. The end. So you will see that Mr. Daly did know his stuff quite clearly, as someone's recorded all this information, and so I wanted to relay that to you because I think it's just pertinent what's going on, folks. It's just pertinent. This is enormously important for people to understand that this case that took place in Minnesota back in the late 60s gives us hope, even though I've gone for over an hour and 22 minutes here on this whole thing, is to elaborate with you that the bankers, are creating money out of nothing. And Mr. Daly himself is, kudos to him. He continues like a bulldog to continue to name. He comes back around, and deals with the issue again because he wants the answer. And I would like to know who this guy is. That is Jerome Daly, because D-A-L-Y, because but I'm afraid he's probably passed away. This was in the 1960s and 70s, so to speak. So that's, he would probably been an older man. I'm guessing he's probably passed, but they did deal away with the judge. They eliminated him. They killed him. They were watching this case because it was important. It was actually, if I understand this, what you were talking about here, this whole deal in this area, this is a small Podunk County, a small area. And the judge had the guts to do the right thing. In fact, he had the guts to do the complete right thing morally. And in reality, so I want you to understand this guy did his homework. And he knew how he was going to have to play with these guys. And he was very fortunate to find a judge who was honest. He was also fortunate to find a bank president to tell the truth at first. And I don't know whatever happened to the bank president, that is, who was there, came from Minneapolis. But he did answer the questions that what they were doing. They were actually creating money out of nothing. Now, you think about this with all the credit, so to speak, you had to pay a mortgage on a house or whatever, you paying this back. So let's say $200,000 today. This house when he bought was now, this is just critical here. It was only $14,000 is what I recollect. And I'm sure that his interest rate was not that bad, but he fought the principle of the whole thing, you see. And this is all in this book. And we haven't even gotten a third of the way of the book, okay? This is over 600 pages of information. And what I'm trying to explain to you that there is hope, that what we're fighting for is for truth. And we want the system to fall because there's people who have paid into this whole thing. People have lost their houses, folks, have lost their houses over 15 years ago. They lost their houses because the banks did an incredibly dirty thing in this country and sold them to foreigners. And none of them got in trouble. So you know that the representatives of your county, of your state, are doing dirty deeds. They're looking the other way and being paid on the table. And very few have the guts to have moral values of doing right and wrong here. That is what is right. So that concludes this deal tonight. And just wanted to share that with you guys. I would appreciate it if you would share this with others. Yes, how you doing, Casimir? Good to see you. Happy New Year to you, my friend. I hope that you understood what I was sharing tonight, Casimirs. And I wish you well. And yes, we're going to continue to share this information because it's important. And so this is a redemption. That is 4.5. That is the manual that many people have put this together. And so the classic case, again, is the deal with Minnesota, what took place. Is actually helps you to see that they create money out of nothing. And then you toil and slave all the time to make those payments. In reality, create out of thin air. And he did the right thing. The judge said simply even about the dollar bills. He came to understand simply that was not real money. It was not, it's just paper. It has nothing behind it. It's not redeemable. How can you pay off debt with a debt instrument? It's impossible. And that's why your country and all countries throughout the world that uses this is that they never actually are able to pay off the debts. This is a system that actually is satanic to force people as slaves to pay over something that is impossible to pay. You see? So I'd encourage you, if you would. Oh, yes. Hello, Lucky Charms. How you doing? Appreciate you being here. It's important that we understand these things so that we can continue to not only educate ourselves, but eventually to, quote unquote, educate others. It's vital for us to do this. There's always hope. And the veil is going to come down. The curtain is going to be rent because we're going to find out who the people are behind the veil and what they've done to us. And they've been doing this for thousands and thousands of years to us, folks. This is not something that's happened in the last 100 years. Yes, here in the United States, yes. But no, it's happened in the past. It's happened in Egypt. It's happened in Babylon. It's happened in Persia. It's happened in Greece. It's happened to Rome. And whoever else has happened to have been destroyed from within. So the truth is always here. We just have to keep searching for it. So again, like I said, we'll try to do another, probably not tonight. It's 10:30 now. I'm pretty tired. I've done 3 videos today, so I'm pretty beat. But what I want to do simply is that if you can, it's very important that you can find this actually online. And I'm giving you the site here. Let me write this down here for you, because that's what I'm reading from. It's a site called PDF Drive. And you do a search for books, and you just simply put in redemption manual 4.5. It's there. And it costs you nothing. It does ask you to become a member. And that's it. And the membership is nothing. It doesn't cost you anything. It's books. And there are hundreds and hundreds of thousands of books here that you can look up. And that's some of the books that I have actually gotten, not this one here, The Secrets of the Federal Reserve, which in reality simply is a lot of the, even what I'm dealing with redemption 4.5, a lot of what they share is coming from this book. Okay. All right. And it's important that you start reading yourself and educating yourself. And I'm doing this basically trying to educate other people to see that we've been fooled. We've been fooled tremendously, and this has got to stop. And one way or the other, the truth is going to get out, and this whole thing is going to collapse. And and actually is going to collapse soon, because basically they're losing control of it. Yes, again, you're more than welcome. You're more than welcome to quote unquote ask questions about this. And the whole idea simply is that, and I've shared this with others, is that your inheritance was robbed by these people. You see, and you need to get your inheritance back. And so the process is, what I understand, is to, and I'm learning as I do this, and I haven't done all this. This is a matter of learning. There have been a couple other people who have done this. Unfortunately, they both have gone. They're no longer around. They don't live anymore. And that is Patrick Devine. All his videos are on YouTube. And that's, there's probably 150 of them, if not more. And then there's a guy named Gene Keating, that's spelled Jeankeating. And he was also the one who has had impact upon, and you can see some of his videos. He's been interviewed. He passed away earlier this year. He was actually helping people. I think he was charging them only $25 a class, which was very reasonable. A brilliant guy. Again, he understood a lot of this stuff, put it well. Then there's another guy who is very young, approximately 30 years old. His initials are PJ. He's in the New York City area as far as I know of, but I'm not sure. But he's also has done things, and he's basically understood the whole thing of what we call the secure party creditor. And also private bank. So what is talking about secure party creditor is doing what I call the ledger. That is, the credits go on one side and the debits go on such and such, just like a checkbook. And what you need to do is you need to begin to work with the Treasury Department to get your money, because it's in your quote unquote your Social Security. That's where your trust is. They put it there. They disguised it. And there's a lot more than that, folks. It's a ton of it. Okay, there are certain particular forms you have to fill out, but there are people who have done this and have gotten themselves out of it. Patrick Devine helped a lot of people. Patrick Devine didn't even charge anything for his classes. He did that on his own, out of his goodness of his heart. Gene Keating is the other guy. I don't know about anybody else. Those are the two major people I recollect and feel like there's respect there for this too. But you can see some of Gene Keating's stuff. There's a guy actually did some interviews with him last year, and he knows it. He knew it just like that. He just click, 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 and he understood that whole way how it works and everything. And this is how we get our inheritance. And with that, we can make it. We can begin to make changes by using. And our trust is worth quite a bit of money because we was the collateral. That's what the whole thing with the birth certificate is and the Social Security card is. We became the collateral for the situation that's taking place under Franklin Delano Roosevelt. You see, all that. Because see, they stole people's gold. And now that is if people volunteer to do that. And so people didn't have any way of actually even paying anything. Can you imagine that? No cash. In fact, a dime was worth a lot of money back then to buy certain things. But it was a manipulation of markets. This is what you don't understand. This is what's occurring right now in our country. They blame it on the whole thing is to do with this COVID deal, but reality simply is that's a screen to what they're really doing over here on this side. They're doing something over here to destroy the West, okay, economically. And over here, people hear all this stuff about the virus and such, and that's all been out in the media. And the people don't pay attention to what's going on here because that's what they're doing. They do this all the time. And so they're always, as you would see, the Wizard of Oz, he's behind a curtain, you see, and they're not showing you what they're doing. It's like a puppeteer, such and such deal almost, but not quite that. Tavistock is to do with that, how they brainwash people and program people. That's another excellent book out there by Tavistock Institute by Dr. John Coleman, who worked at one time for Tavistock. Brilliant works. There's tons of information about it too, not just with John Coleman, but others who worked in this. And if you understood the Tavistock deal, is that they were part of the Frankfurt School. It's all about controlling people and leading them where they want them to go. And that's what they're doing now also. And also how wars are created with Woodrow Wilson when he allowed this whole thing and signed it into law, that is the Federal Reserve banking system. It meant that these bankers, these men behind curtains, so to speak, could create money so they could finance the world wars. And the idea simply is to destroy humanity. That's what the wars were about, is to destroy the best of what we call young men from not only from Germany, from England, France, America, but also with the Bolshevik Revolution that took place, killed probably 75 to 80 million people. Okay. And Solzhenitsyn talks about that. In fact, Solzhenitsyn was a communist at first until he got in trouble when he was fighting on the lines of the Eastern Front. And he said something somehow, I don't know if he got disgruntled, and it was reported real quickly. You see, there were moles everywhere in that particular people. But anyway, the point simply is I want to share with you is that it created these two. In fact, this is how the money system also works. It simply is that they created the Soviet Union, they created Germany. You see, that's why the book by this guy here, Wall Street and the Bolshevik Revolution, is that the bankers created this. The industrialists also agreed to do this. You see, and also with Hitler, they both financed both groups. They financed both of them in order to create a world war. That is World War II. And they also financed the World War I with the Bolshevik Revolution. And it's incredible what they've done. And there's another excellent book, if you ever get a chance, is Death by Government. How many people have been killed by their own government? I can't think of the author right now, off the top of my head. He was a former political science professor at University of Hawaii. And he wrote that book probably in the 1980s, I think it was, or maybe 1990s, and described how many people were killed by all their governments. If you ever get to see a good movie to, in some ways, The Killing Fields, which was done back in the 1980s, what took place in Cambodia. The communists themselves killed people who actually wore glasses. They destroyed a complete class of people who were intelligent, who could think for themselves. And they destroyed those people. They killed them. And there were probably a couple million, if not more, were killed there. But Solzhenitsyn said basically there was probably 75 to 80 million, but who knows how many, probably was even more than that. And the same thing in China took place there. After Chiang Kai-shek, who fought them, in fact, was fighting him, and the American government at one time was supporting him. And they were giving guns such and such. And then what happens simply is someone turned off the spigot. The guns are totally useless if you don't have rounds of ammunition, and they didn't send any rounds of ammunition. So what happened was they were totally useless, and they destroyed it. And if you understand who Mao is, he was actually trained here in the United States in the early 1900s. It's amazing. Our government and our political leaders, but also industrialists, bankers, did this. All of it. So much destruction has happened, and that's not the way the world is supposed to be. That's not the way the world is supposed to be, folks. We are actually brothers and sisters, but yet they've decided to basically divide us and to fight one another. And so that's what they want us to do. And the more we kill of each other means less of us to stand against them, because they're the small minority, folks. They're not the majority, nowhere near. But they have fooled people in many ways. But anyway, I could talk all night. But anyway, I appreciate you all being here. It's valid for you to understand if you're not free, you don't have anything. You really don't, because if you're not free, you don't have the choice of actually practicing that freedom to make decisions on your own. And we're on the cliff, folks. This is serious business here. And the whole idea is, what I gather simply is they're pushing their agenda here to cause harm to all people. And we've got to begin to not only teach ourselves and learn what's going on, but we've got to help our brothers and sisters, neighbors, whatever, to help them see what's going on. Because unless that happens, we're headed for some very dark times in our civilizations. So again, thank you for being here. And there's a couple things I want to share. So again, like I said, look for some certain books here. I'm sure that this book here is also Carroll Quigley is probably also in the PDF. There are other good books. One more book here is a pretty good book. Is this one here. This has recently been done, Skulls and Bones. But this is a subpar. What I'm sharing from what I'm talking about, the manual here, is the primary deal. What I mean simply is to allow ourselves to break the shackles of being a slave. These other books are just pointing out other areas of what I call, they're not minor, but they're important. But what I'm sharing about Redemption Manual 4.5 is to get you out of this bondage. That's what I'm trying to share. So have a good night. And also, I wish you a happy new year to all of you. And may it turn the way we want it to to live in freedom and to love truth. The truth is the ultimate aim of all our lives, should be in that respect. So, all right, have a good night. Take care.